Well, hello again. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Today, we're going to be talking about the Corporate Transparency Act. This is our third webinar on the Corporate Transparency Act. I think our first one was done in November of last year. So if you do have any questions about the nuts and bolts of the Corporate Transparency Act, I encourage you to watch that webinar from November. But today, Chris is going to be giving us a high-level overview of the CTA, and Kathy is going to go into some of our processes with CAMS that we're going to be rolling out. So as a reminder, we are recording this session, and so we do hope that you will tell your other board members what you learned today or encourage them to watch the webinar and all of the webinars that we have on our website at camsmgt.com. We will be fielding questions regarding all the contents of today's session. As I mentioned, it is a large group, so we will try and do our best at getting through all of the questions. We'll let it run. We said we're going to stop the webinar at 5:30, but if there are more questions, we'll probably go another 15, 20 minutes, try and get through as many as we can, and then follow up with some Q&A options after the session if we're unable to get through everything. So this is one of the big change moments for associations. We've seen several over the last years. I was thinking about all the different federal regulations that have come out, going back to the Federal Communications Commission and the FCC, 1996 Federal Telecommunications Act with satellite dishes. Then I think it was in 2006, 2007, we had the Virginia Graham Baker Pool Spa Safety Act, where caused all kinds of headaches around your pool and pool drain covers, and it cost a lot of associations a lot of money. Then after Surfside, we saw some federal regulations with Fannie and Freddie changing their regulations through the FHA, and so now we have the Corporate Transparency Act. What I didn't know when we first started talking about this was it was a bipartisan law that was put together. The president vetoed it, but it still passed. 2/3 of Congress passed this and put it in place. And so here we are. It is in effect. Started, Chris, I guess I may turn this over to you. You can give us some more history of the Corporate Transparency Act. So Chris, I'll let you do what you do. Tell us about it.
Thanks, Ben. Again, my name is Chris Gellix. If you haven't heard me speak before, with the McIntosh Law Firm, you all should see on the screen just sort of my name and the name of this. So to give a little background on the Corporate Transparency Act, this it's a federal law. Now, most everybody in dealing with HOAs, we deal with state law, North and South Carolina. In this situation, this is actually the federal government getting involved in our lives. And really, it was designed, the act was designed to deal with basically money laundering. It's an anti-terrorist type act, and it is run through the Federal Crimes Enforcement Network, affectionately known to us now as FinCEN. And they enforce this. And what it's designed is they're looking for smaller companies, looking for to see who the owners of smaller companies are in the event that there's some money laundering or some terrorist actions, really is where this was initially headed. It focuses on companies with generally a small number of employees with a smaller amount of income. And the crux of it is this is a reporting regulation. It is a reporting law. Congress passed this over the president's veto, as been indicated back in 2021, I believe. And everybody says it's in effect now. It actually starts January 1, 2025. We're talking about it now because come January 1, 2025, there are some things homeowners associations are going to need to do. And of course, all the other companies as well. And nonprofit, and let me just talk real quick. There are, as with any law, where they tell you this in law school, they'll tell you the general rule or they'll tell you the law, and then you spend the rest of the semester talking about the exceptions or the exemptions. It's the same way here. They've drafted this law, and there are 23 specific exemptions. In other words, 23 types of companies that don't need to report information to the government. I don't know if we call it wisdom or hindsight or what, HOAs were not exempted. Now, there are certain charitable type HOAs that may be 501c3, 4, and 7. If you are one of those, you may be exempt. You would need to explore what those are. But as a general rule, HOAs, community associations, condominium associations, all of those types of organizations are required to report certain information to FinCEN. And entities that were formed prior to the end of this year have until end of last year, have until 1/1/25 to report the information I'm going to go over. And folks, just let me just say right now, I'm doing a very, very high level view of this. We could spend probably 2 days talking about the intricacies of this. I don't know why we'd want to. It's boring, but it is something we have to deal with because it's required to be done. But anyway, since most of the HOAs that we deal with were formed prior to January 1 of this year, you have until January 1, 2025 to report certain information to FinCEN, and we're going to go over that here shortly. You're dealing with this now towards the end, second half of 2024, because there has been a lot of, I would guess, challenge, movement, proposed legislation surrounding this on the federal side. There was a case that was brought by a small business association. I can't remember if it's Arkansas or Alabama that went to court back in May. And the United States District Court in that district actually found the Corporate Transparency Act unconstitutional. Now, that decision is limited only to the plaintiffs that brought the action. And there is a consensus in reading the opinion from those of us who practice in this area that there's a pretty good chance that decision is going to be overturned at the appellate level. But as far as a very finite group of small businesses in that district where that case came down, the act doesn't apply. That doesn't apply to us. I'm just telling you what's going on out there. There has also been, in the last 3 weeks, a bill proposed in the House of Representatives to specifically exempt community associations. Being that was just introduced in the last few weeks, it will not go into effect. It will not pass both houses and the president's desk before the end of the year. So you're not going to get an exemption this year, most likely. The crux of it is it's here. We don't know how long it's going to be here for us to deal with, but we have to deal with it now. And so what has to be reported? If you are in a homeowners association, as I said, certain information is going to have to be reported to a website run by FinCEN. What needs to be reported? Well, we have to determine who needs to report first, and that's what we call beneficial owners. The Act, Corporate Transparency Act, basically says if you're an individual who directly or indirectly exercises substantial control over the entity, or you are someone who owns at least 25% of the corporation, you have to report certain information to FinCEN. Now, who are beneficial owners? Because in homeowners associations, as we know, beneficial owners could be everybody who's a member all the way down to directors or officers or managers. In looking at the statute and how it's written, my opinion is board members are going to be required to report. And the reason for that is because board members make the decisions for the community. Every director sits on the board, they go into board meetings and make decisions on landscaping, on budgets, and run the gamut of everything you make decisions on. So board members, in my opinion, will absolutely have to have their information reported to FinCEN. Questions have then been raised, and what about officers and managers? And I have examined this at multiple levels because there's an argument for and against. There's an argument that officers wouldn't need to report because officers only do what the board tells them to do. Likewise, managers only do what a board tells them. The conservative approach to this is, well, we need to report everybody. So anybody who's in the decision-making process needs to be reported. Well, I think that's overly broad because in theory, the members of the association who elect board members are actually then involved in the decision-making process. So if you have a 1,000-member association, would you have to report all the members? That is a very broad scope. So I don't believe it's that broad. I believe it is the board members. Officers and managers are more, if you wish to report them, that is a conservative approach and nobody's going to fault you for that. But at a minimum, I believe all the directors have to report. And here's what they have to provide. So the website, FinCEN website, requires you to put the name of the corporation. So Stone Ridge, Crest, Field, River, Homeowners Association, or wherever. Okay, so that name has to go on there, the business address, et cetera. The legal name, date of birth, address, and copy of your photo ID of all the directors will need to be reported. The website is free. It's a free reporting type analysis and website. So you don't have to pay. The government's not making you pay to report the information to them. So in this situation, towards the end of the year, I will advise all my clients, you're going to have to go on the website and file this information. The interesting part and the things that everybody's going to have to watch is that every time there's a change, you're going to have to report again, which is why reporting officers and managers in addition to board members can be a problem because, as we all know, directors are elected at annual meetings. Unless someone resigns, those normally don't change on a monthly basis. But officers are appointed by the board. Managers are hired through contracts. So those could change much more frequently. So anytime there's an annual meeting election where there's a change, anytime there's a resignation, an appointment, a removal, potentially new officers, new managers, or in a small community such as a condominium where you have 4 units or 8 units, where somebody owns a quarter of the units, that all is going to have to be reported. Everybody who fits one of the descriptions, directors, officers, managers, or 25% owner is going to have to report and update every time one of those changes. That can be a daunting task that is going to have to be monitored. And we'll go over the time frames when you have to report those changes here in a minute. I have been told, as we go into fiduciary duty for a second, I have been told that the website is secure. As we all know, nothing is absolutely 100% secure. This being run by the federal government, I would hope we could rely on it, but I can understand some people being a little leery of providing that information. The reality is the information that is being provided is really no different than what's on your tax forms when you file your taxes every year. It's name, address. They just do want a copy of a photo ID, which is already out there in the state realm anyway. So I would not be too skeptical of the security part, and you're really not giving over more information than the government already knows. Why did I say that? Because more than likely, there's going to be some pushback from directors, and I understand that. But in North Carolina and South Carolina, homeowner associations, directors have a fiduciary duty of care and loyalty to act in the best interest of the association. And I'm going to talk about the penalties for not filing here next. But I'm bringing this up now because if you are a director and refuse to provide the required information, in my opinion, that's a breach of fiduciary duty. The government is requiring the information. There are penalties if it's not reported, and the entity will suffer the penalty. It is also my opinion, and I believe it's echoed by others who practice in in this area of law, that it is, in my opinion, prudent for a homeowner association now to consider amending its bylaws to change the qualifications to be a director or an officer if you're going to have officers report. And to include that in the qualifications that to be a director, you must agree to comply with all governmental reporting requirements. I've never seen bylaws with that information in there. I believe it is prudent to put that into an amendment to your bylaws and try to get that passed. At a minimum, my opinion is that a board should adopt a policy to be handed down through all future boards that you must comply with any governmental reporting requirements, or you must either resign or you will be removed. And we can talk about potential how that works in the Q&A if it comes up. I don't want to get into it too deep right now. But there are penalties if you don't comply with this, and they can be pretty steep. If you do not report when you're told to report, you can incur the association can incur up to fines of up to $500 per day for a cap of $250,000, and it's a criminal offense. Now, I don't know how you're going to put a homeowners association in jail, but the beneficial owners who don't report possibly could be. It's a big deal to the government. This is a heavy penalty, which goes back to what I was saying on the previous slide. If a director refuses to comply and refuses to supply this information, it is potentially damaging to the association and to each individual member, because any fine is going to come out of association coffers. So it is my opinion, the government is wanting this information. It can damage the association by fines. At a minimum, if you don't report it, you are not acting in the best interest of the association if you do not supply that information. So again, be aware of that. Now, if you report the wrong, now I say all that, the penalties, there are a couple of safe harbor provisions in there. If you put in inaccurate information, somebody puts in a wrong number or misspells a name or puts in the wrong address, you got 90 days to fix it. That safe harbor is there. If something like that happens, it needs to be corrected quickly. If there's any sort of inquiry as to how it happened and the potential for fines like that, that's when you call me or call your attorney and let us handle, hey, look, this was a mistake. Let us deal with the feds on that. I believe they wrote that in there to give small businesses like homeowners associations some leeway in getting this information together and getting it reported accurately. Likewise, if you recall a couple of slides ago, I indicated that anytime there's a change, you have to report it. You have 30 days to report the change. So if you have an annual meeting in November 1, your change in directors must be reported by December 1. If you miss that, again, there is the safe harbor provision of, okay, we forgot, it was negligent, we didn't do it intentionally. And we reported it as soon as we realized we had not reported it in time. The provisions of the act that safe harbor there will hopefully be able to say, hey, don't penalize us. It was a mistake. And they write that in there. So again, to give the association some leeway, some corporations some leeway. So it is there, but we do want to, again, be mindful of the timelines going forward. I'm about 20 minutes in now, Ben, and that is the high level view. Certainly we can talk about more questions, but at this point, I'll stop sharing my screen unless you want me to address anything specific. You're muted, Ben.
All right. Yes. I know a few questions have come in, but I did want to just comment. I mean, this is affecting 400,000 associations across the country. We've got 20,000 in North Carolina and maybe 10,000 in South Carolina. Of all of the managed associations, which is probably 50% of those two numbers. I mean, this is a huge undertaking for the federal government. So the last thing we want our board members to be concerned with is immediately fining. We've got some time. We need to comply, but there is some time to get all this done. And so that's one reason we're starting the rollout now, prior to January 1. But so the next session, I wanted Kathy to talk a little bit about what is the CAMS process. You mentioned the free process, and that is certainly an option. But we CAMS were asked to put together a solution for our board members to help meet all the different requirements that you outlined. And so there's some things that the federal site does not do that we felt was important for associations to do. So Kathy, I wanted to turn it over to you, talk a little bit about the process that we've put together, then we can get into the Q&A and help answer as many other questions as we can. So Kathy.
Okay, thank you, Ben. Thank you, Chris. So I will be quick and run through this, but I think it will answer some of your questions. So you can see my screen. CAMS has introduced a process. As you know, there are choices and we provide services, and when there's a need, we come up with a solution. So if you go online and do the filing, that is certainly an option through the fincen.gov website. This is the Privacy and Paperwork Reduction Act notice from that website. And the process can be lengthy and confusing. Given that board members are volunteers, we understand that you do not have a lot of extra time. And so we offer you our services to handle this for you. It's easy to do. You just let CAMS know, and we will jump into starting the process. We set up that company in this secure portal. So the reporting company is responsible for being set up with all that information. Chris mentioned the tax ID, address, etc. And then the beneficial owners are attached to that entity. So CAMS sets it up for you. CAMS will then send you an email to each board member. And then when you click on the email, you will register for the FinCEN Fetch portal. And as Chris mentioned, you will provide your information. A lot of this information is already in our system. And so we do include what we can, but the system that we are offering here to use will also use the picture ID that you provide. So you are going to upload either a driver's license, passport, or something issued by the state that is a personally identifying document. And this software will then read your driver's license and complete the form for you. So instead of spending 60 to 170 minutes, you spend about 60 to 90 seconds doing the process. It then comes back to CAMS, and we do not see any of your information. All we see is either you have submitted or not submitted. The benefit of using our services is that we do have staff who are tracking this. If you go into FinCEN individually, each board member goes and files, you won't be able to look up and see the status of your organization. This third-party portal allows us to track this and to send reminders when everyone has entered their information, then we can file. So this is just an example of the tracking dashboard. And also we can send reminders if somebody has forgotten. Now, there's the free option, and there are other services being offered for this. As your management company, our focus is to ensure your privacy. And one of the questions is who can have the information once it's in the system. So this lists those instances when your information will be accessed through the FinCEN government website. But when it's coming through our system, we do not see any of that information. It is all behind a secure portal, and it goes directly into FinCEN Fetch and then into the government website. The security for FinCEN Fetch is another important thing. And there are other services out there. I've seen services asking you to fill out a form, give it to the service provider, and then they go online and type it in. We don't consider that to be a good idea. We do not want to see your date of birth or your personal driver's license number, any of that. So the platform we use has got a lot of security built into it, and it is connected to the government website through an API, which is also a secure link directly into fincen.gov. Of course, if you want to do it yourself, there are many board members who own businesses and already have a FinCEN ID number, and it's really easy for you. The main thing is just to keep in mind that as your board members are transitioning, somebody needs to be herding those sheep and making sure that things get submitted. When there's a change, it has to be filed within 30 days of the change occurring. And we are going to be doing our level best to watch when an election is occurring and contact the new board members, educate them about this, help them to get the filing done. So we are your partner in this to the extent that is practical and logical, and that is the value that we feel we bring. So that's a quick summary of what we are offering to assist our boards with complying with the CTA.
So the questions are rolling in. So Chris, I think the first one may come to you, but do HOA boards need to make a copy of the report available to the membership, or can the transcript of the report itself be kept confidential as a record of the association?
The answer to the first part of that is I don't see anything that requires the association to disclose that information to a member. The second part of that is that some sort of record that would be subject to disclosure pursuant to statute in either North or South Carolina? I haven't examined that. My opinion is no, it would not be. It would certainly need to be something in the corporate records to show that it was done. And I did want to clarify one thing when I talked about the penalties. The civil penalties would be levied against the association. Potential criminal penalties would be incurred against the individual potentially individual board members who refuse to report. So that's why I think I've said, I don't know how you put an association in jail. You can't, but you can certainly fine them. So going back to the question itself, no, I don't see that as something that needs to be reported, shown to the membership. It needs to be a record that it was done. And obviously, the part about using the service that you're going to provide is the updating is going to be essential because once this thing hits January 1, any change, you have 30 days. And after that, then and if you're late, the feds may say, hey, you're late, we're going to start finding you. And then you got to hire me to go fight them. Hopefully it wouldn't be much of a fight, but you don't want to do that. So it's very important to keep up with these.
Yep. So that gets into the next question. As a board member, how can I check to make sure all the other board members have filed in a timely manner? And how do we manage our board to protect the association? So Kathy, that might be one you can answer.
Yeah.
Yeah. So you can't, in the fincen.gov portal, you can't look that up. In our portal, we do have the ability to track and report on that. But basically, if you do it individually, either all the board members can maybe meet around the dining table and pass a computer around and fill it in, or you can give your information to one person who does it, or, there's different ways to do it, but really you can't go and search in fincen.gov to see what's there and who's there. We will have that history in our reporting system.
Yep. And so a link goes out to each board member's email address, and then they get access to create an account and upload their information. And we would be, privy to the information, not the information that's uploaded, but the fact that they have completed the task of uploading the information. So,
yes. And the system will also verify if there are errors or not. So it will let us know if something was missed.
Okay. Next question is, did you say we have to include our pictures? I completed my own for the company, not the association, and I don't recall that it required a picture.
Is that for me or is that for
Chris,
Kathy?
I'd probably say that's for you.
So, and as you asked that, I'm looking up specifics. My understanding is if you go onto the website for them, they ask for a specific governmental ID number. However, I've also seen information, and this is the one I've seen the most of, that there has to be something uploaded. And I understand the reasoning behind it, like a picture with ID that has to be uploaded because, again, if you look at the purpose of this, they're making sure that the people that you say are on the board are actually who they are. And I'll just give you a quick story as to why I think they want the picture ID. This started way back in 2020 when there was a failure to be able to locate the owner of a company that had land right near an airport in California. I don't know if it was LA or San Francisco, one of the bigger airports. And it was shell company after shell company after shell company, and they could not verify anything because the information they were given was all handwritten or typed up, but they couldn't verify that what was typed up was accurate. And it took them a long investigation. I think it took them 6 months to find out. And the reason that was an issue is because you can't own certain amount of property that close to the airport, and they need to know without it being reported and all this. So, it makes sense that they would want a copy of the ID for the person that said, hey, I didn't see where I had to load one. The information that I have is that they want a copy of it.
Okay. So if our annual meeting were to hold elections in November, we report any changes in November, do we have to file a report again in January for the next year?
No. Once you file, you're filed, and you only have to do a new filing when you change something.
So if your board members never change,
you're filing once.
You're filing once. So, and some boards have that. There's some
that's true.
There are some 20-year board members.
Yes,
probably reluctantly, but they're 20-year board members. Okay, which address does an owner board member report if renting the unit in the association? That unit or where the board member actually resides?
I think we're splitting hairs. Whatever address is on your ID is the one I would report. Wherever you get your mail.
So you mentioned changing the bylaws takes a vote of the community. What if they don't vote for this? If
they don't, they don't. But I think that's the prudent step. The alternative, and until they do vote for it, I'm going to go back to my recommendation is that the board has to adopt a policy of what they will do in the event that a director or officer, if that's who you're required to report, refuses to comply. And that there's a couple modes of thought. My opinion is that the board member who refuses to comply needs to be basically set apart, should not be taking an active role in anything, and basically should not even be allowed to vote. And then a special meeting should be called to remove that board member because they are exposing the association to massive liability. And until that occurs, they need to be basically shunned. There needs to be a wall around them. They don't participate in any fashion. And I know that sounds harsh, but again, look at the exposure that you are getting if they don't report. So bylaw amendment is the best way to change the qualifications. Certainly a resolution or with policy in there about the requirement to report if you are a director or an officer. And if someone refuses to, you obviously need to call a special meeting and get them off the board. And hopefully the members will do that. And until that occurs, build a wall around them so they don't make any decisions.
Okay. Are your property managers trained to proactively notify the HOA when a reportable event occurs? So I may take that one, and Kathy, feel free to jump in. But one being a new regulation, new requirement, we are trying to put as much attention on introducing this to our board members, but also make sure that our managers understand what's going on. We've held sessions internally, just like we're doing externally. So we are working hard to make sure the managers know what they have to do to help educate the board members in the field. In addition, we have people in the back office that are also working to make sure that our back office processes are driven. So, and that's one of Kathy's responsibilities, to make sure her team keeps our team in a line. So she has people paying attention to when board members transition. We track that through our software. And so anytime that a board member changes, Kathy's team is going to be working on making sure that we get the right information and start the process. So Kathy, anything to add on that?
Yeah, we've got the community manager who's talking to the boards, but we also know when they're mailing out an annual meeting packet or when they're scheduling an electronic election. And so those are triggers to us to reach out and remind you of your obligation, whether you decide to use us for reporting or whether you do it yourself. We're going to contact you at that point in time.
So I know you answered a question about the $495 fee in writing, but do you want to, the question was specific to, is it a one-time fee or is it reoccurring? Can you comment on that?
Yeah, so it's an annual fee, and it covers the obviously the initial reporting, but also the update when the board members change, and us monitoring the status, reporting for you what has been done. It is by association, not by board members. So just one flat fee just for the service and the time spent. And also, again, privacy and security. These things are very high tech, and there is a cost associated with using the service provider. And so we feel it is the right thing to do for our volunteers, because you do change and transition and move, and you have so many things, so many balls in the air you maybe can't remember. So we're there to try and support you in the best way we can.
So while directors, go ahead, Chris.
I wanted to follow back up on the question about whether an image needed to be submitted. I'm on the FinCEN site right now, and this being a new law, I don't have it memorized yet. So when someone says, well, I really need to do that, I go back and read it. It needs name, date of birth, address, and the identifying number and issuer of your driver's license, passport. And it reads, an image of the document must also be submitted. So it is a requirement. And to the gentleman or lady that submitted that question, I'd go back and submit it now. I'd add that to your submission.
So while a director's having to report seems straightforward, the greatest concern I have is whether committee members must also report to FinCEN. Chris, thoughts on that?
Yeah, committee, I do not believe that committee members need to report. The reason for that is committees simply report and advise. They do not make decisions. The beneficial owners of an association, as I put on the slide, the ones that make the decisions. The substantial decision-making power are the board of directors, arguably the officers and manager. Again, we went over that. Committee members don't make any of those decisions. And further, I've seen boards assign committees to, for example, handle landscaping and actually sign the contract with landscaper. I don't advise that, but I've seen it happen. Even in that case, I would say no, they don't have to report, because again, they are acting at the direction of the board. The board makes the decision, not the committee.
So Chris, two questions back to back regarding associations being nonprofit entities. and why an association is subject if nonprofits are excluded from the act.
Sure. So in both North and South Carolina, homeowners associations, and I need to qualify this. In South Carolina, you don't need to be a nonprofit corporation to be a planned community. In North Carolina, you do. However, 99% of them in South Carolina are a nonprofit corporation. You are formed under the state laws as a nonprofit, meaning you don't have a profit at the end of the year. You're taxed differently by the state. And your property, your common area is taxed at a lower rate. That's the benefits of being a nonprofit per the state. However, that means nothing federally. Your charitable elections are tax implications. Your 501c3 charitable organizations, your 501c4 and 501c7 are the type of entities that the Corporate Transparency Act says are exempt. A nonprofit homeowners association that has no tax election like a 501c3, 4, or 7 is not exempt. And that's where the feds draw the distinction. Simply forming a nonprofit corporation under state law doesn't get you there. You have to have the charitable or other, for example, I think 501c4s are having to do with a recreational facility. So in other words, you're formed for the sole purpose of furthering that recreational activity, recreational thing. So 99% of the community associations in North and South Carolina do not have those tax election options. You're not charitable. You're not focused on something outside of your homeowners association, and therefore you're not exempt.
And I think we are recognized as a 528 and not subject to the nonprofit exemptions, as you mentioned.
Yes.
So when there's a change in board membership, who will be responsible for recognizing the change and updating? Kathy, this might be one that you can take.
Yeah, so the reporting person, the individual who is the beneficial owner, is responsible for reporting those changes within 30 days. And when you are using a service to assist with that, then it's on you, your obligation to notify us to make the change. However, given that you all are volunteers, and as I said, sometimes this is not your main priority, we are going to try and help in at least where we can, which is when we know you have an annual meeting and there is an election. But if you were to sell your house and move or anything like that, there's no way we can know that. So really the responsibility rests on the individual board member, and our goal is to support you where practical.
Okay, so what if the board has elected CAMS to manage the CTA? So who will be held responsible for the missing information? And is there a way to verify all the information as submitted? So I think we've answered those two questions, but ultimately the responsibility lies with the board, although Kathy just said we're there to help facilitate the process. And then the information being submitted is going to be done through the FinCEN portal. And we've talked through that FinCEN portal, but there is a verification process as part of that portal. Through the government site, there's no verification process, and that's one of the reasons that we did put the portal in place. There's two more questions about the fee. As Kathy mentioned earlier, that fee is $495 for the FinCEN portal and the service along with the reporting aspect of it. It is, if you go to fincen.gov directly, you can fill out that information on your own. And one of the next questions had to do with, can a board member for a very small association collect that information and then enter it themselves? So the answer to that is yes. you can collect your other owner's information, driver's license, social security information, whatever you want to supply, and push that information through one entity or one individual and upload that into the fincengov.com website.
So
Ben, can I make a comment real quick?
Yep.
Because of the nature of this, my opinion is that if you can use an outside resource, and I'm not saying use CAMS, I'm just saying if you can use an outside resource that can help you check and make sure it's done properly and reminds you to do this and will follow up and make sure and provide you with the information to make sure everybody's registered. To me, that is an extra step of protection for you as an individual board member and for the association. So obviously, if the person who reports, if you have a small association and an owner wants and a director wants to report everybody, if something's wrong, it's on you. You as the individual board member who is registering everybody, if it's wrong, it's your fault. So you bear the liability potentially. So having a system like CAMS has here is certainly, in my opinion, beneficial for associations to consider because of the extra layer of monitoring and protection. That's all. So.
It's about shifting the risk, isn't it, Chris? Like with anything, when you hire someone.
Well, I'm not even sure it's a risk shift. It is a little bit, but it's more of a minimization of the risk. I mean, if you have 5 checks on you as opposed to 1, you got 5 things checking to make sure it's done right. It's there's a lot less chance for things to go wrong. And no one ever wants to deal with the federal government. So, you know.
Kathy, there are a couple questions regarding board members changing and how the data is going to be updated and managed when a change does occur.
Yes. So if a board member term expires or they resign from the board, we have to report when there's a change. We have to report the entire slate each time. So let's say Bob, Jill, and Mary are on the board, and then Bob and Jill remain, but Mary's gone. So whether she is replaced or not, we have to file a new report showing who is on the board. And so the way you get removed is when you're not on the report.
So, yep. So every time that we update a new report, and your name is not there, you will no longer be recognized as a board member in the FinCEN database. So, how should the initial submittals be handled if you're going to use the CAMS process? Yeah,
so you can just let the manager know. We did send out an information piece at the end of July and asked you to reply to that. You can reply to that if you want, or just let your community manager know. What we need is an instruction in writing. It could be in your board meeting minutes or an email instruction to us, and that will be enough for us.
So Kathy, why don't we go ahead and mention where you've placed additional information around? I know you've prepared a number of documents and outlined some of the processes in a Q&A document. So you've made it available through the portal. Do you want to highlight where that is?
Yes, there's a folder under documents called CTA info, and there are some documents in there and also some presentations that cover this information.
So, Chris, you mentioned the drop dead date to send information into FinCEN.
Yes, if you were formed prior to this year, your association is not brand spanking new. You have until December 31st, 2024 to file. Starting January 1, 2025, if you have a board of directors in place and something changes, you will have 30 days to make the change. Otherwise, the potential penalties could be incurred.
Okay, if all members do not report, but some do, is that acceptable? And I know you commented on this, but
The way I read it is no. Beneficial own, they want all beneficial owners. And so the issue comes back to, okay, what do you do? And it, we hope, we believe that, if we have 5 directors, 4 report, 1 do not, the association takes whatever steps it can to shield that member and remove that board member, and then the feds come back and say there's a problem here. We're hopeful that we can explain the situation, and if there's any penalties, that be directed at that board member and not the association. But incomplete reporting is a problem. Would implore on everyone that if you are a director and you don't want to do this, then it's my opinion, your fiduciary duty is to resign and have someone take your place who is willing to report. It is that serious because, again, of the potential penalties.
And I'll just say, we don't want board members to actively resign their role. We need board members. We need board members.
And let me comment on that too, because there was this big. I've seen a number of webinars. This whole thing would present a chill to volunteerism. And as I think I stated early on, the information you're providing, the government already has it. It's not like you're giving them more information than they don't already have. Everybody who files a tax return, they have this information. It is simply another website for a different regulatory body that wants this. And so I would wholeheartedly say, do not let this discourage you from volunteering. If you want to be a director and make decisions for your association and you have a reason you want to do that, don't let this deter you. This is not something that you should be scared of. This is not something that you should say, oh, the government wants more information, I'm not going to give it to them because they already have too much. They've already got it. It's just another regulatory body.
So, Kathy, if a board has already completed this for their association, what do they need to do to make sure that they communicate that to CAMS?
Yes, just send us a copy of your completion notice and we will log that. As Chris said, it's important to make this compliance record part of your association documents, and so we would add it into the file.
And if boards are going through their annual meetings and will no longer be on the board, say November, do they need to wait until after that election to do the filing, or should they file now?
Are you asking me that?
I could ask.
Can you ask it again, because I didn't quite follow it.
Well, if the election is not until November and they know that they're going to be coming off the board, do they need to worry about filing now, or should they wait until after the election? And
no,
Kathy,
that's the whole point of waiting this long is to why file knowing you have to file again in November. So I would wait. My opinion is you wait. I wouldn't wait into December, but if your annual meeting's in November, wait till the annual meeting, hold your election, and then report.
And I'll just, by waiting, keep in mind that, if 400,000 associations are going to be doing this in December, those sites may have some problems. So I'd say the earlier you can get this done, and that's one reason we've started pushing it now, is to start getting, the thousands of associations and board members to learn about the process, but also be compliant.
Also, we've started, some associations have started the process, and so we send out the invitation, and then one person responds and the others don't, and then we send reminders and then someone goes on vacation. And so the truth is, as with boards, it takes time to get something done. So we are giving you time, but we're going to need you all to really step into this and be part of making it come to closure once we send you those invitations. So we will be sending out some more communication here at the end of the month, and we're going to ask for a 30-day deadline because we know you have annual meetings, but if you don't have annual meetings, it's important to just get it out of the way, because as soon as Thanksgiving and Christmas comes around, then that's pretty much the end of the year and not a lot gets done anymore sometimes.
But well, I think strategically, if you've already had your annual meeting, there's no reason not to file. Sure, someone can resign or move or something, but just go ahead and get your initial filing done. That way, you're right, Ben. I mean, and Kathy, if 400,000 homeowners associations could crash the FinCEN site, then what do we do? So,
but Kathy, I don't know if you've mentioned the update portion of the $495. If you want to maybe talk about the update, and then if there are multiple updates, it's not, well, talk about the pricing.
So the $495 is an annual charge, and theoretically, when you have your annual meeting, we will file the update, and that's included in the fee because it's annual. If you have a bunch of people dropping off or moving or coming and going, then we do have an additional update fee of $100. But we are not here to collect fees. We are here to provide a service to you and to help you be in compliance. So to the extent that you register now and then you have an election, that would be included in that fee because it's the annual fee.
Okay, Chris, there's a question about fractional ownership and if that would apply if the FinCEN regulations.
you be more specific?
Well, the specific question, would CTA apply to a single residence with fractional interest? It's set up with articles of incorporation for a nonprofit corporation with declaration, covenants, conditions, and co-ownership interest.
I would say that applies. Yes, they would have to file.
Whether it's a condominium or an association, it would still be subject as a corporation to compliance.
Understand that the Corporate Transparency Act is for corporations in general, not just homeowners associations. So whether you are a homeowner association or some other small business, you're going to have to report. In the situation that you provide fractional ownership, yes, they would have to report. Now, unincorporated associations, and there are some in South Carolina, there shouldn't be any in North Carolina, but occasionally there are. I don't know if CAMS manages any of those, but they are not required to report because they're not incorporated. This is strictly for corporations.
So, Chris, I know you talked about this a little while ago, but does CAMS have to be listed on the specific HOA report since they are helping manage the community?
That is a difference of opinion. You ask lawyers about this, we'll give you a difference of opinions. There are some who are very conservative that say it's directors, officers, and managers because they're all involved in the decision-making process. The way I read the beneficial owner definition is that those who make the decisions are the ones that are the beneficial owners in our situation for homeowners associations. A manager doesn't make a decision. An officer doesn't make a decision. They are agents of the association acting upon the decisions of the board. So I come at it two ways. If you wish to make sure that you are covered, then you report everybody, directors, officers, and managers. If you don't believe that that's imperative, and I believe there's an argument that it's not, it's the board members that need to be reported.
So our legal counsel for our company has said that because of the contract language, it specifically states that we act as an agent of the association, and that's why CAMS is not filing.
And that is that managers are agents. They even if there is decision-making power, it is assigned to them by the directors. And so they're not, in the end, it's not CAMS is making the decision, it's the board. Likewise, officers act at the directions of the board. You may, give officers broad powers. President of the association may have the authority from the board to look at a landscape contract, 3 of them, and make the choice himself and sign it. That situation is more unique than regular. I would say that president probably ought to be reported because he's making decisions. But generally speaking, it is the board of directors where all the decisions lie, and it is they who are the beneficial owners.
So you mentioned this earlier, but any simple language of what would need to be updated in the bylaws?
Simple language. Well, first thing is, if you want to update your bylaws, make sure that you contact your counsel because you're going to want to draft it correctly. But language in your qualifications to be a director, and every set of bylaws should have in it director qualifications. For homeowner associations, it's usually be a member, and that's it. Sometimes you don't even have to be a member of the association to be on the board. Some language in there reads you have to be up in good standing. Okay. We're going to update that section to read board members are disqualified from serving if they refuse to comply with governmental reporting requirements. Or you can word it another way and say any board member must affirm prior to election in writing that they will comply with any and all governmental regulatory requirements for reporting of information, federal or state. Something like that. That's a very broad, but that's the language that I've been toying with. I've submitted that language to a couple of associations with the idea that, yes, you're still going to have to get the members to vote for it. It should be a no-brainer vote. I wouldn't see why members wouldn't vote for it, but we all know getting people to come to a meeting to vote on these things is usually very difficult. So there are other ways to get it passed through action by written ballot or electronic voting. But the general language is to add language into there to require directors to submit to all governmental reporting requirements.
So Kathy and or Chris, you may know the answers, but if a driver's license expires during the period that they are serving, how would we know that it needs to be updated?
Yeah, so sorry, Chris, in the FinCEN portal, because you took a picture of your ID and it has read the information, it does get stored in the FinCEN portal. It's just my staff and I cannot see it, but it will send us a little flag saying this has expired. Now, if your license has expired and it's still the same license number, you do not need to report a change. It's only if the license number changes that you need to report that as a change.
And Kathy, I know you're typing an answer about the annual fee versus a board update fee. Can you speak to that?
Yeah, so because we have this portal and we are maintaining information and we are tracking changes, maybe you don't have any changes in board members, but we are still managing the filing and archiving your reporting status as of the current time. And so that's why we have an annual fee. So if you have specific questions about your association, please reach out to your manager. We'll be happy to work with you and make sure that we're providing the best service. And our goal is to bring value to our clients and to make your life easier and not add burden. It is a cost of doing business. The association is incorporated. It is a business. And this is a fairly nominal expense, which protects you as the volunteer for the board.
So I know we are 4 minutes over on time, so there are a number of questions still remaining. So if you do need to drop off, please feel free to do so. We'll continue answering as many questions as we can for another probably 10 or so minutes. So if you do have to drop off, we thank you for attending. You can find a recording of this presentation at camsmgt.com under the board member resources section, so under webinars. So a couple of questions about the $100 update. Notify attenders of the charge during the year if there's a member change. You said that was $100. Kathy.
Yeah, so the annual fee again includes an update. Assuming you register now, you have an election in 9 months, that's an update, so it's included. And then the next year begins and you have your election updates included. But if somebody changes outside of the election, you have people move out or resign, then there's a $100 fee for off-cycle updates. That includes as many changes as you want. So if somebody resigns and you fill the position, that's one update. So it's not per person, it's just per the work of the preparing the report and filing.
And this is also not on a calendar year. This runs for 12 months. So if you sign up in December, it runs through December, or is it?
Yes. Mm-hmm.
Okay. So yeah, not a calendar year, but so from the date of sign up for 12 months following the date of sign
Yeah.
up.
And we know that with this initial round, you know, it's all new and it's all getting set up. So if something changes a month after we register you, then we're not going to charge you $100. You know, we'll have to all kind of get to level one.
So, and I know we mentioned this, if a board member dies or becomes otherwise incapacitated, how are they removed? And that would involve an update. If you're replacing it with an individual or just removing an individual, an update still needs to be sent when that occurs.
Yes, I was like, are they being removed from the board or removed from the report? They get removed when we file the report without them on it.
Okay. New question. What if your governing documents constitute a standing committee that is separately elected from the board and empowered to sign contracts and spend money? It's essentially operating as a sub-association, even though there is only one EIN number. Should those committee members be included?
Based upon that description, I'd say yes.
And they're making decisions. And I know we have a lot of neighborhoods that make decisions in their own area, but they are not recognized under multiple tax IDs. So any spending authority, right, Chris?
I would say that's the ultimate is if you're spending money, if you have the authority to make a decision to spend money, then yes, I would say you have to report it.
Okay. Question, Kathy, can CAMS set up the account with the FinCEN? So why don't you talk about CAMS involvement with the FinCEN database?
So the CAMS service is where we set it up in FinCEN Fetch and we send you the email and you enter your information directly and then that gets sent to the fincen.gov website securely through the FinCEN Fetch integration. We will not go online and type in your information for you. Our staff are prohibited from taking your driver's license and birth date and doing it for you. It's too much of a security risk.
Yep. So if you want to do it yourself, that website is fincen.gov, and you can walk through the process of entering that information in the FinCEN site. Just as a board member, work with your other board members to make sure you get that information, or everybody gets that information entered. So scrolling through, I know we have a lot. Can we get and receive a copy of today's slides? Yes, that will be made available again through the camsmgt.com website under board member. You can go to webinars, and we do have all of our other webinars posted there as well. So lots of great information on the camsmgt.com website. Our board member has 3 members. Can we input information for 2 board members in one application, then complete the second application for the 3rd member? Kathy, do you know, Chris?
No.
I don't know that.
If you go to the website, every time you have to put in all the HOA information and then the beneficial owner, and then you submit. Next person, all the HOA information, then the beneficial owner, submit. If you do it through our service, you just upload your image into the link that we send you, and then we do all that other work for you.
Okay. Kathy, will CAMS have a written policy that we as a board can adopt and put in place when we get the bylaws updated by voting? You know, highlight where you have our policy located.
Yeah, so we are not advocating one way or the other for bylaw amendments. That would be your attorney you want to talk to.
But the CAMS policy is posted on the portal under CTA, right?
The
So
process,
you can,
yes.
or the
process.
CAMS process, you can find that, right? Clarify the free filing options as opposed to the fee-based options. I think we've answered that. Do board meeting minutes need to be submitted when a change happens?
Yeah, so we are working with the manager when there's a meeting, then usually the manager is involved with the minutes and they will notify my team that the change has occurred.
Is there interface? If something is wrong in CAMS, I don't understand that question. I'm trying to scroll through as many as I can, so lots of duplicates. Our HOA is 20 houses. The developer is listed as the declarant and is at an address where another in town other than where our subdivision is. Why is he still the beneficial owner?
I have that question up in front of me. I'm not quite sure what is being said there, but let me say this. If the declarant is in control, the declarant appoints a board. Those board members, whoever they are, have to be reported. If the declarant owns 25% or more of the lots in the community, assuming it's a planned community, I would submit that he has to report as well. So it would be the board plus him. Understand what you're reporting. You're not reporting the board of directors. You are, but you're reporting what's called beneficial owners. So beneficial owners could be the board of directors, as we've discussed. It could be committees. It could be a declarant. It could be, you could have 15 people that you have to report. I don't know. It's going to depend upon each association. At a minimum, the board of directors is going to have to report, but we're reporting them as beneficial owners, not directors. Okay. That's one thing I want to be clear about. Okay. Same way, I saw something in there about a sub board or something like that. I think we addressed that. If the sub board makes decisions, then my argument is they have to report. There was also a question I saw in there about if someone has an association debit card, do they need to report? Well, I need to know more about that. Why do they have a debit card? What is it for? What do they do with it? But if they're making decisions independent of direction from the board, then I say, yes, they have to report.
So, Chris, you had talked about board members resigning if they refuse to comply. What about if board members refuse after they've been elected? What should boards do?
So again, there's a couple of different modes of thought on this. At a minimum, as I said, they need the board, the remaining board needs to call a special meeting to have that board member removed. They're breaching their fiduciary duty by not complying with governmental regulations. In the interim, at a minimum, they need to put a wall around that board member and have him not make any decisions, not be involved in it. That board member may cause a ruckus, and I will defend that lawsuit if he files at any time, because that board member is opening up the association to massive liability. I have heard other attorneys say, well, the board should just remove him, appoint someone in that person's place. let the chips fall where they may, and then go ahead and call a special meeting. You can, to have the members formally remove that person. Okay, you can do it that way. I have no problem defending that either. I think that is a scorched earth approach. It may be necessary. The options for a board to deal with this are limited simply because of the law. The law says you can't, board members can't remove other board members. They have to be removed by the membership. So that limits our ability in this situation to, deal with what I would call the rogue board member who doesn't want to report. I can defend just about any action for the protection of the association. I would love to defend that case. So at a minimum, put a wall around the board member. At a maximum, the board remove them through resolution, appoint someone else, and then either way, call a special meeting to have the members removed.
So I'm going to only maybe two more questions, but should a board resign should all board members resign due to government overreach? What happens?
You pray a lot. I have written a blog on this. That should never happen. A board member's fiduciary duty, in my opinion, extends past the point where they're no longer on the board if they have resigned en masse. Because as a board member, I have a fiduciary duty to act in the best interest of the association. That includes, if I'm going to resign, making sure that there's someone in my spot to run the association. If all three, however many they are, resign en masse, I believe they have breached their fiduciary duty because they now have left the association rudderless. There is no one there to be in charge. Now, that doesn't answer the question. What happens? What happens is the members of the association, strictly through the legal means that I know of, would have to put a petition together to call a special meeting. Somehow that would have to get scheduled, noticed, and then a board elected. There's a couple other things that can occur through court intervention. For example, a receiver appointed to run things until a board can be elected. A court-ordered meeting could occur. That requires court intervention. I can't stress strongly enough, though, that if a board members believe that this is government overreach, if you resign en masse, my opinion is you are opening yourself personally to liability in the event the association runs into trouble while they're trying to fill your spots. If you're going to do that, resign one at a time and appoint somebody.
Okay.
I think that is my opinion is that's not necessary here, but I understand the reason.
Yep. So the last question is about making this information available to all HOA members to view, and that's certainly open an option. We have again multiple webinars, including this one, probably it'll be on for Monday maybe, but it's at the camsmgt.com website. This is also, we have information in the portal right now. I think that portal is only available to board members, Kathy, unless you want to make it available to homeowners. But so there is information out there about the Corporate Transparency Act, and this is something you're probably going to continue to hear about over the next many months. This is new, not only for CAMS, this is new for every management company in the country, and it's new for every association in the country. So management companies are all trying to figure out what to do, how to do it. Some are doing something, some are doing nothing. And so this is really going to be interesting to see where this goes and how it's going to be handled. As we talked about, there are lots of different services out there. Some attorneys are offering services as well, and that's something Chris may be able to assist with in the future. But again, this is new for everybody. We did go through this, something similar. I mentioned it earlier, but the Virginia Graham Baker Pool Spa Safety Act. Some people called it the Pool Management Company Stimulation Act, because, it was when they were replacing every pool cover in the bottom of the pools, and every 5 to 7 years we have to go in and replace those pool covers, and that was because of a federal law that came in and cost associations a lot of money for the right reasons, and it was to protect everybody. But it did require change, and it did require a large outlay of cash. But there was a lot of risk and work involved in changing those pool management or pool covers. So, but we all got through it. We got through that one. We'll get through this one, and we're going to keep our fingers crossed that we will see some changes as it relates to homeowner associations, but we just don't know what those changes will be. So, but with that, Kathy, Chris, any parting words of advice?
I would just say I'm going to be putting out a write-up about this next month. It'd probably be repeat information, but it is, I think everyone needs to just keep informed about this. Whether this is going to be a permanent thing or 1 or 2 year thing, I don't know. It is not something you need to be scared of. It's something that can be handled fairly quickly, easily, should not deter people from running and volunteering for their associations. So that's all I'll say.
Yeah. So, well, thank you all for attending. Thank you for sticking it out with us. There's still almost 100 folks on the call. So we do appreciate your time this evening. I hope we've been able to answer a lot of information, or get you information about the Corporate Transparency Act. And if you do have additional questions, please feel free to reach out to me, Kathy, or your community manager, and we can help get more information out to you or the rest of the board and or your membership. So thank you again, and good night.
Thank you.
Thank you, Chris. Thanks,
Thank you.
Ben. Bye.
Good to see you all.
Bye-bye.